In Victoria, estate litigation is becoming extremely more common and complex. It's important for advisors and clients then to know what their position is in the event a claim is made against an estate or they wish to make a claim against a deceased person's estate. I'll be touching on the position in Victoria and the considerations they would make for either of these two applications. In Victoria, when someone makes a claim, there's a 4-part test that the courts will undertake. The first part of the test is to determine if they're an eligible person. If that's satisfied, the court goes on to the next limb to decide if the eligible person, the testator, had a moral obligation to provide for them in their will. The third test that the court will apply is to determine if the will failed to make adequate and proper provision for the maintenance of the eligible person. Lastly, if they've satisfied these 3 tests, the court will then decide what amount ought to have been awarded to that person. It's extremely important to note that if the person is going to make a claim, they have 6 months to do so from the date the grant of probate or grant of letters of administration is issued by the court. In the event you're acting on the other side of these disputes where it's for the legal personal representative, so that's either the executor or the administrator, it's important that they obtain advice if they become aware there may be a claim against the estate. When acting as the legal personal representative, there's certain obligations they have and duties to the court if a claim is made, and they also should be aware of any risks and personal liability which they could have if they were obviously to take steps with the estate prior to the 6 months expiring as to when someone could make a claim against the estate. So it's a perfect time for advisors to touch base with us so we can work out what steps the executor can take and what they shouldn't take until the expiration of that time. In the next part of this series, William will be touching on ways and steps that you can take as a testator to minimise the risk during your lifetime of someone then later challenging your estate.